Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5084. Andrew Dutt, Major, U.S. Army, appellant, versus Daniel Driscoll, the Honorable Secretary of the Army. Mr. Thayer for the appellant, Mr. Silverman for the appellate.
Mr. Thayer, whenever you're ready. The start of a new term, and we have new lighting in this courthouse, so now we can see. So this is it's a great new beginning. Please, whenever you're ready. Here comes the sun.
Thank you, Your Honor. Chief Judge, Your Honors, may it please the court. My name is Dylan Thayer. I am here on behalf of the appellant, Major Andrew Dutt. As this court has held in Frizzell v. Slater and reaffirmed in Jackson v. Mabus, military correction boards are required to address non-frivolous arguments put forth by applicants. Here, Major Dutt made 3 non-frivolous arguments which were not addressed by the correction board. First, that ASOC administrators arbitrarily administered room intrusion exercises. Second, that ASOC administrators failed to adhere to the student evaluation plan by not placing Major Dutt on academic probation and by failing to provide him with retraining prior to retesting. And third, that ASOC administrators violated Army Regulation 623.3 when preparing Major Dutt's Form DA 1059. Neither the June 2021 decision on Major Dutt's application nor the May 2019 decision by the correction board addressed any of these 3 non-frivolous arguments. When we look at the text of the 2019 and 2021 decision, almost the entirety of the correction board's analysis is devoted to boilerplate recitations of statutory and regulatory language.
I think I have a sense of what you would like from us, but what is it that you would ultimately like from the corrections board?
Yes, Your Honor. I think that what Major Dutt would like from the correction board is for them to fairly consider his argument that any adverse impact that he suffered during the course was as a direct result of these failures by the course administrators.
What would that get him?
That would get him a certification that he completed the course, Your Honor.
So that is where I am a little unpersuaded. It seems like even if the board did everything perfectly well, even if his arguments are total winners in terms of things that went wrong before the correction board became involved, I don't see how a correction board can order him to receive a certificate for a course he didn't successfully complete.
So a few points on that, Your Honor. So the correction boards have broad authority under 10 USC 1552 to correct any military record. Any means any. So they can correct this course certification for a certainty, Your Honor. Second of all, I think it's important to contextualize the alleged failures that Major Dutt had on the course. There's been reference in the Secretary's brief to 17 indices of failures by Major Dutt in the course. That comes over the course of 4 months and 500, 600 or so evaluations. And those 17...
I think there's no dispute in the record that the people who grade him failed him and gave him a failing grade.
The people who assessed the course on the final day of the course did not pass him, Your Honor.
And
yes,
I can see correct. Where he could go to the correction board and say, you know, all these procedural things went wrong. I wasn't given a fair shake and I should get to do it again. I should get another chance. But even if the board as a formal matter has the authority to grant any relief, it seems like it would be pretty wrong for the board's relief to be a diploma for a course he did not successfully complete.
Sure. Well, I think that's for the board to determine, Your Honor.
But if the board should not determine that, if it would be arbitrary or unreasonable for the board to do that, then you're here asking us to remand to a board that should ultimately not give you what you want?
Well, I would dispute that it would be arbitrary for the board to do that, Your Honor. I think that the
If I
board.
went to college and I got a bunch of Fs. I'm not saying he deserved the Fs, by the way. He may have been a great student. It may have been a completely unfair shake that he got. But he did not receive passing grade from the course. If I went to college and I didn't get a passing grade, I don't understand how the remedy for a correction board would be I get the diploma anyway.
So again, Your Honor, as I mentioned, I think it's worth contextualizing the alleged failures that he had. His contention, Major Dutt's contention is, as I mentioned, these 17 failures, that's not the same as receiving 17 Fs, Your Honor. That's out of 500 or 600 evaluations, receiving 17 poor evaluations. So it's not receiving 17 Fs, Your Honor. It's really more like receiving 17 As if you split it out percentage-wise. So I think that Major Dutt would push back.
17 As and 483 A pluses?
So 17 As meaning like, I'm being a little, I'm being a little glib, Your Honor. What I mean is, if you look at the total percentage, I can't do the math off of the top of my head, but my, best back of the envelope estimate is that 17 out of 500 or 600, that's something like a 95 to 97% pass rate. So when I said 17 As, Your Honor, that's what I meant.
Are they all equally ranked? How do we know that?
Excuse me, Your Honor?
Are they all equally ranked?
So these,
In college, for example, you have a 5-credit course, you have a 1
Sure.
credit course.
sure.
How do we know how they're ranked?
So
I mean, the program that we get in the appendix is largely blacked out. You can't even tell what these various hoops that he has to go through, what they consist of.
yes, Your Honor. So as Judge Walker mentioned, this is, at the end of the day, it's an up or down, pass or fail course. So each of these matrices all play a part in how that assessment is made in terms of whether he's passing the course or not. So
I thought there was one indication that even if he failed one course, that was enough to kick him out.
yes, so the secretary does mention in his brief how there is language in the student evaluation plan that says even one failure by a student is enough to merit removal from the course. I think that it's important not to take that overly literally, Your Honor. I think just as,
How can you take it otherwise?
well, I mean, we all know in certain areas of life, there's something that a person could do in a job or any situation that would be so egregious that it would merit removal immediately. But the student evaluation plan also states that students who are having academic difficulties are required to be placed on academic probation. So I think that language which says that the secretary can remove anyone for, that the ASOC course administrators can remove anyone for any failure, I think it's important not to read that too expansively. There are some failures that are so egregious that they would merit immediate removal from the
I
course.
just want to follow up on on 2 things that Judge Walker posed to you about maybe he'd be entitled to, if we rule in his favor, be entitled to take the course again. He already had that right. Isn't that correct?
That is correct, Your Honor.
He already had it and had it for 12 months after he failed the initial course, and he didn't take advantage of it.
That's correct, Your Honor. Yes, I think that Major Dutt feels that he was placed in a very disadvantageous position, that the course was arbitrarily and selectively administered. I think that that's been substantiated through the subsequent IG investigation that was performed. And I think he felt that continuing to take the course again under such conditions would be futile.
The other question I wanted to follow up on, excuse me, is the advisory opinion that came out in November of 2023, was it?
I believe it was earlier than that, Your Honor.
2021?
Yes, Your Honor.
Yeah. Okay.
I think that's correct.
He received, your client received a letter sometime in the winter, I think it was January, saying that if you wanted to oppose this, which found the 17, and if he wanted to oppose this, do so in 30 days. He didn't do it. And the board went ahead and entered a judgment against him relying on the advisory opinion. Why is it, how do you overcome that?
Well, our office had requested an extension to the
But
30
not-
days and
but
the
30-day
board.
period in April, the 30-day period had already run.
It's my understanding that the 30 days, that was several years ago. It was frankly, prior to my time at our firm, but it's my understanding that the time had not run prior to the request of the extension, Your Honor.
The
I'd have to
letter-
look
the
in the
letter
record to be certain about that.
I thought the letter went out in January. Am I wrong about that?
I can't be certain about that, Your Honor, but it's my understanding that that request was made in timely fashion.
So, Mr. Thayer, my understanding from your briefing is that you are only questioning the reconsideration order, not the underlying order. So you're only challenging the 2021 reconsideration order.
Well, that's correct, Your Honor, but I think it's important to assess these two orders in conjunction
But
because,
you're not challenging the 2019 order.
well, but the district court determined that the 2021 order was insufficient. And the district court said, yes, this order is insufficient, but if we rely on the 2019 order, then it's sufficient. So I think it's,
Well, it is a reconsideration order.
Sure.
We don't expect an Army, Board of Corrections to restate all of their reasons from an initial decision.
correct, Your Honor, but they didn't really state any reasons in the initial decision either. And so I think that that's what I'm getting at is that,
But there were no reasons. I mean, your specific argument is that they failed to consider 3 arguments that you suggest were non-frivolous. So
Sure.
even if that is the case, you still have to show that failure to consider those things or to even mention those things was prejudicial to Mr. Dutt.
sure.
And I'm not sure, where have you shown that you can overcome the harmless error?
Yeah, yes, Your Honor. I think that for the reasons I mentioned in speaking with Judge Walker, these errors were not harmless. These were non-frivolous arguments that Major Dutt made before the correction board. The correction board in 2019, the only analysis that they gave of this case, which wasn't boilerplate recitations of statutory language, was the record shows applicant was not meeting core standards in many areas. That doesn't respond to Major Dutt's arguments, and they're required to respond to those arguments
What is
because
the evidence, though, that if they were to respond to those arguments, there would have been a different outcome where he received a failing grade across a number of metrics?
the board is required to correct any error or injustice in the record.
No,
And
that's not what the statute says. The statute says if the secretary, as he considers necessary, it's a lot of discretion placed in the secretary and therefore in the boards.
there is, Your Honor, but courts have consistently found that failure to correct a clear injustice in the record is in of itself arbitrary and capricious. So the secretary has that discretion, but it can't be exercised in an arbitrary manner. And one of the ways that a board can exercise that discretion in an arbitrary manner is not reviewing non-frivolous arguments. And here, Major Dutt showed that he was not placed on academic probation when he was required to be placed on academic probation. He was not provided proper retraining prior to retesting. And he was arbitrarily given certain exercises. And all of these things had an impact on his course failures.
I have one question about what you just said about probation. I understand your argument to be that there's an entitlement to probation. I wonder, what if the thing, let me just quick preface. I said this earlier, but I want to be clear. I'm not saying he deserved any of these bad grades. He may have done a great job, and it may be that his evaluators were very misguided. That's not what's really before us right now. But what if the thing that his evaluators felt was insufficient happened on the last day of the course? It can't be that you have an entitlement to probation rather than if the failing thing you did happened on the last day, it can't be that you have an entitlement to probation because the course would be over before your probation would even start.
That's true, Your Honor. And that's an interesting hypothetical, but that's not what happened.
Doesn't it show that probation is not an entitlement?
I wouldn't say so, Your Honor. I think
How can it
that
be an entitlement if you're not entitled to it?
if the time for probation has lapsed, if it's the very last day of the course and you do, and again, this goes to what I was talking about when Judge Randolph asked me the question about the ability of the course instructors to kick them out for anything. If you do something on the last day of the course that's so egregious that it does merit your removal from the course, then yes, the time for academic probation has lapsed and your removal from the course is merited in that scenario, Your Honor. You're correct. But in this scenario, the things for which he was given a poor evaluation did not happen on the final day of the course. They happened earlier. And in fact, he was given good evaluations.
The two bad room invasions happened pretty late, right?
They happened late, but he was
Do you
initially,
remember when, how late?
I don't remember exactly how late. They happened somewhat late, but certainly early enough that he could have been given retraining and retesting. And it's important to note also, he was initially given favorable evaluations for those. And then they were re-evaluated and he was given an unfavorable evaluation on the very last day of the course, Your Honor.
Surely it is not the job of this court to revisit all of those determinations that were made in an intelligence course run by our military.
No, of course not, Your Honor. I would never make that argument.
That's sort of what it sounds like you're asking us to.
Oh, no, quite the contrary, Your Honor. All that Major Dutt is asking is that his arguments be fairly considered by the correction board. And based on this record, it's important to
So I just have to say, I mean, this isn't a rulemaking where we sometimes remand for an agency to provide more reasons about a rule, right? That affects
Sure.
private rights going forward prospectively. I mean, this is essentially, a board of corrections is much more like an adjudication, right? An adjudication of some kind of, he'd like to have his records corrected. And then
Sure.
that's
It's a review of an application.
Right, it's a review of an application, and if we determine that there's substantial evidence in the record to support that determination, why isn't that sufficient? I mean, what would be the reason to remand for the board to say a few more words about what they did?
So this court has held in Christ versus Secretary of the Air Force that the board must give a reason that this court can measure as to why it made its decision.
A reason as to arguments that might affect the outcome.
Right.
Not as to all of the reasons. And so the board could fairly.
Well, if the board finds that certain arguments are frivolous, the board is mandated to say that too. The board can't simply, that's where the standard in Christ, the board has to give a reason the court can measure commit. If the board finds that the arguments are frivolous, they have to indicate that and they have to indicate why, so that this court can determine why the agency made the decision it made. Otherwise, there's nothing for this court to defer to.
Colleagues have any further questions? Thank you.
Thank you.
Good morning, Your Honors. May it please the court, Bradley Silverman for the Secretary. Dutt's argument on appeal is that the board failed to consider 3 points that he had raised to it. This argument fails for 3 reasons. First,
Matt, can you speak up a little bit, please?
oh, I'm sorry. Is this better?
Yes.
Dutt's argument fails for 3 reasons. First, the 3 points that he had raised to the board were not significant. They could not have changed the outcome. So the board was not, in fact, required to consider them at all under this court's case law. Second, and in any event, the board did consider each of his arguments when the opinions are read fairly and holistically. Third, and in any event, even assuming for argument's sake that the board did not consider these arguments, any error was harmless, essentially for the same reason that his 3 points were not significant in the first place. Let me start with the first point. This court has held in Roberts v. United States that it is not error when the board fails to consider an argument that is not significant. Likewise, in Frizzell, the case that my colleague on the other side was citing, this court determined that it was error for the board not to consider an argument that was not frivolous on its face and this is the language that is omitted from Dutt's brief, and could affect the board's ultimate disposition. And this follows from the State Farm standard, which provides that an agency acts arbitrarily and capriciously when it entirely fails to consider an important aspect of the problem. If an argument is not significant, if it's not the sort of thing that could make a difference to the outcome, it's not an important part of the problem. Now, each of Dutt's arguments individually on their own terms are not meritorious, but that's especially so when you consider not just the way he's saying that the board erred, but that in conjunction with the relief he's requesting, which is to essentially be retroactively deemed to have passed the course, qualified to perform highly sensitive human intelligence collection operations for the military.
Is there an age limit?
An age limit for the course?
Yeah.
I am not aware of one, and I am not aware of any reason to think that he would have
What would
aged out.
his title have been had he passed the course?
I'm not sure what the title would have been.
Intelligence officer?
I'm not sure what the title would have been. It would have been a certification that he could perform these operations. I don't know specifically what title would have accompanied that.
I had a question similar to Judge Randolph's. What would the course have gotten him? Like, what could he do after successfully completing the course that he couldn't do before?
Well, he would have been eligible essentially to perform a certain type of sensitive human intelligence collection operation. I'm not exactly sure what that would entail. This is a highly classified area, and so the record does not go into great detail. I'm not withholding anything from you. The record just does not provide this. As you can see, it's extremely redacted.
Would
But-
it have been a promotion?
Promotion, I'm not sure if it's a promotion exactly or more like a certification. You can do this, which is not
The reason
necessary.
I'm asking that question is twofold. If in fact the boards retroactively said he passed, would he be entitled to back pay? If it amounted to a promotion?
I don't believe so, but I'll be very honest. I cannot say that with certainty. I don't think that's the case, but I would be lying if I said I knew that for a fact.
But we don't want you to lie. So.
I'll do my best not to. So let's look at each of the arguments that he makes. First, he says that the course instructors selectively administered room incursion exercises, but the record makes clear why he was given additional room incursion exercises. He had previously messed up a different assignment, and these additional exercises were a way to provide him an additional opportunity to succeed. So far from holding him to a higher standard, this was giving him an extra chance to not perform poorly. To the extent that there was any inconsistent treatment, it was to his benefit. Second, he argues that the course instructors were required to put him on academic probation. And that is just not what the relevant language says. He focuses on the language that a student who performs poorly, quote, is subject to academic probation. And he construes the phrase subject to mean they must put him on academic probation. But that's just not what that means. To offer an example, if your employer says employees are subject to random drug testing, what that means is they might drug test you, not that they definitely will drug test you. Here too, to say that you're subject to academic probation.
That same subsection though says students will be given mandatory remedial training. That seems more like a guarantee than the subject to probation language.
It does say that, but there are a couple of points on that. First, he was in fact given some retraining.
But you all disagree about that.
Well, actually, I don't think so, because in his own brief, he acknowledges that the course, the room incursion exercises, at least that he had been told that they were provided to make up for his previous shortcomings in other areas. Now,
But let's say I'm persuaded by him that he was not given remedial training. I think you can still win. So tell me how you can still win.
okay, so he was not given, let's say he was not given remedial training. Even so, the most that argument could establish for him is that he would be entitled to take the course again. If that's the relief he's asking for, it'd be a different story. But he's not asking for that, and in fact, there's no dispute that he can take the course again. He was allowed to, he chose not to. What he's instead asking for is, don't just let me do it again. Instead, just say I passed. Even accepting his arguments that he was not given training, nothing about that means that he actually passed the course.
And I think it would be, quite unreasonable for the board to say, you didn't pass, you should have been given the training so that you learned the skills to allow you to pass. And it was wrong that you weren't given that retraining.
Yeah.
So what we're gonna do is we're going to say that you did pass and have the skills necessary to do these very sensitive intelligence operations. And then next thing you know, this guy's gonna be, behind enemy lines undercover as an intelligence operative without the skills to survive and without the skills to protect his fellow agents. And that just seems like a very, very unreasonable thing to ask the corrections board to do.
Well, I agree completely. Yes. I mean, I think it's important to remember this is not just an academic exercise here. If he were to get the relief he seeks, that is what would happen. There are real stakes on the
None of that,
line.
I think, none of that, you might not like this as well, is what I just said. None of that changes that you look at this record and there's at least a decent chance that what happened is he noticed some things in this course that were bad practices, including not protecting sensitive information. He blew the whistle. The people he blew the whistle against got mad at him and they punished him by not giving him the training or the fair shake that he was entitled to. And I think there's a decent chance that happened, but I think it doesn't mean that he gets a diploma that he didn't earn.
I agree with you on the second part. I think it's speculative to say that this, that he was retaliated against. That is certainly what he says. The evidence for that just isn't there.
Are there whistleblower protections for members of the military? He doesn't bring a whistleblower claim.
He doesn't bring a whistleblower claim, no. If there are no further questions? Thank you.
Thank you, Your Honors. I have a few points to make in response to some of the things that my friend across the aisle just said. First of all, he mentioned that none of Dutt's arguments could have changed the outcome. I think it's important to contextualize again the obligation that this court and that other courts have found that military correction board has to thoroughly review the record, correct any injustice, and explain why an argument is frivolous or non-frivolous. So I think that if the board had found that an injustice had occurred, they have an obligation to fashion remedy. They didn't explain why, in response to Major Dutt's arguments, they were not going to fashion a remedy in his favor. There was also some mention about providing a benefit to Major Dutt by giving him room intrusion exercises that weren't given to other students. Those were the room intrusion exercises that he failed. So I think that Major Dutt's contention is, how can it be said to be a benefit to me if I'm being given exercises and then I'm failing them, and that's the reason I'm failing out of the course? I think in conclusion, I'd like to direct this court to two pertinent sources of information. First, in Jackson v. Mabus, Justice Kavanaugh, writing for this court, stated very forcefully, in response to an application put forward by a plaintiff applicant who, it must be noted, did not even contend that the correction board hadn't thoroughly reviewed his arguments. Justice Kavanaugh said, "This court has previously cautioned the boards for correction of military records that they must sufficiently explain their reasoning in order to have their decisions sustained. Despite our admonitions, the board's explanation for denying Jackson's request was thinner than it should have been, unlike the board's detailed explanation for denying Jackson's initial application for correction. We again urge the relevant boards to take care to sufficiently address each non-frivolous claim raised by an applicant for record correction."
What's their caseload? Do you know?
Excuse me?
What is their caseload? Do you know?
The boards,
Yeah.
they have thousands of cases every year.
And how many members?
So there are different panels within the board itself. Each panel consists of 3 members.
With thousands of cases.
But there are multiple panels, as there are multiple panels of this court, Your Honor. On page 33 of his brief, the secretary concedes that the board's overall conclusion, quote, was not expounding upon each of Dutt's discrete arguments.
Mr. Thayer, you're out of time, so if you could just wrap it up.
Yes, thank you, Your Honor. That's all I have to say.
Thank you. Case is submitted.
Case number 24-3014, United States of America versus Jeffrey Henry Williamson, appellant. Mr. Kramer for the appellant, Ms. Lloyd for the appellate.
Good morning, Your Honors, and may it please the court. I think this is a very simple case in the end. The Supreme Court, as recently as 2 months ago, talked about the importance of interpreting statutes by their plain language and not adding anything. And they said our task is to give effect to, not nullify, Congress's choice to include that factor in some provisions, but not others. I submitted that in a 28J letter, Esteras versus United States. I think it was decided the last day of the term, where they talked about the well-established canon of statutory interpretation that the court should not add anything. And they said in Oklahoma, and this to me is essentially identical or indistinguishable from this case in Oklahoma versus Castro Huerta in 2022.
Mr. Kramer,
Yes.
on page 17 of your brief, you say that at the trial court, the defendant suggested that the court dismiss the charges and stay the dismissal for a minimal period of time to allow Buettner to file a 4246 certificate in North Carolina. I think I have at least that much right.
Yes.
Okay. And I think during that minimal period of time, the implication was he would continue to be detained at Buettner to allow Buettner to file a certificate if it chose to. Am I still right?
Yes. Sorry. And I think it's pronounced Butner.
Oh, thank you.
Every time I've been
Okay,
there.
you looked confused. and I
Call it
wondered,
that, yes.
Am I saying 1 or 2 or 3 confusing things? So it sounds like maybe just one so far.
I would not pass an intelligence test, so everything's confusing. to me.
Okay, Butner. So that's what the defendant asked for. And I'm wondering why we shouldn't just read the order to do that and only that. It's true the order uses the phrase "to be examined," but it's not totally clear that the district court's order orders the examination as opposed to it says ordered the defendant shall remain at FCI Butner for a reasonable period of time not to exceed 45 days. It seems like that might be the order. Then it does explain its reason for that order. It expects that he will be examined and there will be a determination of whether to file a certificate or not. But if the order only orders detention for a reasonable period of time, 45 days, and dismisses the charges but stays it until that time elapses, it seems like the district court may well have done nothing more than issue the order that the defendant invited the district court to issue.
Yes and no. No in the amount of time. I think what I said at the time to the district court was a minimal amount of time. And I believe I said 7 to 10 days,
Okay.
which I think in retrospect was stupid of me. And I should have said 2 or 3 days.
I look forward to his
but-
IAC appeal. next
But,
month.
well, I think he files those quite frequently. So 45 days is the statutory time for an examination under 4246. It's way, I wouldn't even say it's in the ballpark. I think it should be 2 or 3 days. Frankly, he's been there at Butner for 7 years, 2 years completing his sentence and 5 years pretrial in this case. And he had a competency exam and a sanity exam at Butner. And the notion that Butner needs 45 days, and I just want to get back to the no part is about the amount of time. The no part is also the government's motion was entitled for an evaluation pursuant to 18 USC 4246. And it said at the very beginning, for a reasonable period not to exceed 45 days to be examined to determine whether the Butner should certify pursuant.
And I agree. I mean, maybe, I think the title could have been better. The title of the government's motion could have been better in order for my theory to be correct. The to be examined language in the government's motion is mirrored by the to be examined language in the district court's order. If the district court's order could be read either way, and if you're saying that one way would be, unauthorized by statute, it seems like, why would we presume that the district court did something it wasn't authorized to do when we could read the order to say the district court is merely doing something it is authorized to do?
Because the district court said the opposite, said exactly what it was not authorized to do, which is to, in authorizing the direct, quoting
Where are you in this?
the first page of the district court's order, ECF 196.
That's a parenthetical quoting another case.
It's about the Gordina's
Yeah.
Ortiz case, but what he says is, in authorizing the directive file at 4246 necessarily contemplates the temporary commitment of that person, so the director can conduct the evaluation. It's clear that this is an examination or evaluation, whatever you want to call it, being ordered. You can't, the government in its brief slaps a number of different names on this. They call it a preliminary determination. They say the scheme contemplates it, a preliminary assessment. I wouldn't mind. I mean, my argument is what it was in the district court. They cannot have an evaluation or examination of any type because that's authorized by the statute in different situations.
Can I interrupt you, or I will?
Sure, you're the judge.
I will. I can. Why is it that you're not standby counsel, are you? You're the real deal, right?
I'm not sure he'd call me the real deal, but for the appeal, I'm counsel. Yes,
You're
counsel.
counsel. Okay. Your client, why is he even covered by 4246?
Well, because I agree, there's some question about that.
That's not a tricky question.
No.
The reason I ask is 4246 only covers people who are hospitalized. And I've looked through this record, and at Butner, there are 4 facilities. You've been to Butner. There are 4 facilities. 3 of them are fairly new. One of them is a medium security, low security, and then another medium. And then the 4th one is a hospital.
The medical center.
Medical center. He's not in the medical center. He says, I'm in FCI 1. So if he's not hospitalized, the statute only deals with hospitalized people. Why is he even covered by 4246?
I think that's a good argument. It was not made in the.
It's not an argument, it's a question.
No, I think you're right. But Mr. Williamson represents himself in the district court and doesn't let us really do anything. I think that's an argument that could have been made and
One of the
will be made.
One
I'm
of the
sorry.
ways you get around it is, I suppose, is that he would be examined in the medical center. And that would, so therefore, he would be hospitalized. But then there's another problem with the order that I have, because the director, according to the order, is not the medical center director, it's the FCI 1 director. That seems to be a mistake in the order. And then, okay, that's just an observation, but I want to move on to, have you read Judge Choflat's opinion in United States versus Berry?
No.
It's exactly on point. Exactly what happened here is exactly what happened in the Berry case. And Judge Choflat, you talk about statutory interpretation, goes through about 4 or 5 pages interpreting 4246. And he comes up with the proposition, which I think is irrefutable, maybe have, that 4246 doesn't, only deals with what the director has to do. It doesn't deal with the question of what to do before the director acts. And that's what we have here, is a situation not covered by 4246A. It's dealing with how do you give the director the opportunity to make his judgment?
Well, if I can.
I'll give you the citation to Berry.
If I can go back.
It's 142 Fed 4th, 184.
If I can go back for a second, the question about the hospitalization, I think is a interesting question, but it was never raised in the district court. But he was in there for actually medical care. He had.
He had medical care, I understand.
For a long time.
Yeah, the back part. But that doesn't say that he's in the hospital. He's being treated. He was being treated in FCI 1.
But also, they can do the evaluations. They don't have to be in the medical center to do the evaluations. They can.
According to Judge Choflat's opinion in Berry, they do. Because there are only 2 facilities, Judge Choflat wrote, in the United States that have the capability of doing 4246 examinations. One of them is the medical center at Butner. I think the other one's in Missouri.
Well, there's one in Springfield, there's one in Rochester, Minnesota, there's one in Carswell, Texas. There's a whole bunch of institutions that do the exams.
I'm wrong about that. The Springfield one doesn't have the capacity to do a 4246. And in Berry, the prisoner was transferred from the Springfield Medical Center to Butner 4.
There's a bunch of the cases refer to the proceedings taking place in Rochester, Minnesota.
So maybe that's.
So I think it's in Rochester. There's an institution.
Nevertheless, the point that Judge Choflat makes and that I'm asking you is, where in 4246 does it say even a word of giving the director the opportunity to make the examination that 4246 contemplates?
It doesn't at all. It just says
So stop there. If that's true, then what Judge Walton did in this case is not a violation of 4246. It can't be, because he's ordering the same as in Berry, he's ordering the whoever it is, the director, to do an examination.
Well, he has no authority to do that under the statute. The statute lists, I think, 6 instances where an examination can be done. And judges just can't willy-nilly order examinations of people. They have to abide by the statute.
Willy-nilly, he was representing himself. And in order to make a judgment about that, and not only that, but if you read the colloquies that went on for years, the guy seems to be mentally ill. And so the question becomes, what do we do? Release him, even if he's dangerous, and then have the examination? No.
Well, the government repeatedly says that there's ample evidence of his dangerousness in the record. Why the director of the facility at Butner can't issue the certificate is unexplained in the record without an examination. The statute never provides for an examination unless the certificate is filed. And it's a very, the government.
The certificate is not the examination, is what you're saying?
The way the district court in Puerto Rico and Cruz Ruiz set it out, and the Fourth Circuit in the Perkins case set it out quite distinctly, that the first step is to file a certificate.
Yeah.
After the certificate is filed, then there can be an examination.
You don't release somebody before you make a judgment about whether to file the certificate.
Well, the statute says the filing of the certificate stays the release. The statute says that.
Yeah.
There's no provision otherwise to stay the release, although in the district court, I did say for a minimal period of time, which now we're a couple of years later, and that should be at most a couple of days. I mean, they did an examination of, ironically,
That's a couple days, yes, but in Berry, which is 2025 case, the prisoner had to wait in line because Butner MC was so backed up with 4246 requests that they had, it would first come, first serve. And so what happened is not only that, but then the facility head of Butner Medical asked for a 30-day extension beyond the 45, which the district court granted. And I'll just one more point. If I remember, your brief argues that Judge Walton didn't have any authority because he's not in a court that's the closest to the Butner facility, right?
right, he's not in the district where Butner's
But
located.
that's not an issue here. That order doesn't deal with that. And in Berry, what happened is it was an it was a Michigan court that ordered the examination. And when the certificate came down, it was the North Carolina court that held the hearing. And that's perfectly consistent with Judge Walton's order here because he doesn't say who's going to hold the hearing if there's a certificate.
No, he said he would not, but what he did order is that whether the director should file he said, ordered the government's motion for an evaluation pursuant to 18 U.S.C. 4246 is granted. I mean, that's as clear as it can be to me, that he's granting an evaluation pursuant to 4246, which he has both no authority to order.
For the determination of whether to issue a certificate.
But that's something that appears, an exam for that purpose is nowhere in the statute. Absolutely nowhere in the statute. I'm sorry. No, that's good enough.
So a question I have is, even if I were to accept your 4246 argument, that the court had no authority for that, how does that intersect with the pretrial detention that was ordered under 3142? Because that pretrial detention is still in place because the dismissal order was stayed. So I guess, if that order is still in place, I guess I have a question about whether the 4246 order is immediately appealable because there's another basis for his detention. And also in general, I'm just trying to understand how those two things interact with each other because there's not much in the briefing about that.
Well, I think, first of all, the government has never challenged the appealability, obviously, but
That's a jurisdictional question.
it's not just the detention, it's the compelled examination that is the bigger intrusion, or according to Weisberger and Godinez-Ortiz. It's not one or the other. But the compelled examination is the harm to Mr. Williamson. That is.
Sure, but if there was no compelled examination, but he's still subject to detention under 3142, then he could stay there until the director of the facility decided to issue a certificate if they chose to.
That would end because the district court has dismissed the charges, but stated pending this appeal.
Right.
And so his detention would end if his order for a further detention and a compelled examination was reversed. Then it would go back to the district court for the dismissal to be signed off on. We did not. Now, Mr. Williams, it's a strange, Mr. Williamson represents himself. And so the issues he raised. So at one point I did say, I think 7 to 10 days was the words I used. I now think that's too long in light of the time that's passed, but clearly the director at Butner has the information they need. This whole thing arises because Judge Walton ordered an exam that he had no authority to order, which was the sanity exam. That can only be ordered if a defendant files a notice to raise insanity. But he ordered it over the objection while the government stayed silent and only later said that exam shouldn't have been ordered. But that's the only reason we're here, because he has already said, I don't need to abide by the statute. I can order whatever exam I want, whenever I want, essentially. And
So if we were to vacate this order, which is the relief that's being sought
yes,
by Mr. Williamson,
yes.
then procedurally, the district court would have before it the Rule 48A motion to dismiss.
Well, I think
Or-
not more than that, he's already granted that.
Right, but he granted that in this order, right? So if we were
Yes.
to vacate this, then there would be a pending Rule 48A motion?
Yes, yes.
And then,
And that would be granted, I assume, as under this court's rulings on Rule 48A, I assume that would be routinely granted.
Mr. Williamson would be released? Would there be,
Well, in the time after this court's decision and the mandate issue, then there's the mandate to issue, there would be plenty of time for the director at that point, if they thought it was justified, because according to the government, there's ample evidence already in the record, so no examination is needed in any event. But if it went back like that, there would be ample time then before it actually landed back in Judge Walton's lap, there would be ample time for the director to file a certificate then. If the director thought it was warranted.
Would we have the authority to stay our decision long enough to allow a preliminary assessment by the warden to
Well-
decide whether to issue a certificate?
Well, when you say preliminary assessment, I'm not sure what you mean. There's been plenty of review of Mr. Williamson he's been at Butner now the last 2 years of his prior sentence and for 5 years pretrial in this case.
So let me ask this. Would we have the authority to stay our mandate for 45 days, during which time the warden could decide whether to issue a certificate?
Well, this court's mandate doesn't issue for 52 days.
There you go.
So I think that would be more than enough, obviously. The 45 days, that's the opinion, and an extra 7 days. So as I understand it, the mandate wouldn't issue for 52 days. That would be more than Judge Walton afforded them. But what they wouldn't be allowed to do is the order allowing the evaluation or examination would no longer be valid.
I want to understand.
they would just be able to issue a certificate of.
Yes, they would have 52 days to issue a certificate.
I want to correct something. I said Judge Choflat, I meant Judge Wilkinson, because the Berry case was from the Fourth Circuit.
Yeah, I'm sorry, I'm not familiar with it. It's never been cited that I know of by anybody in this case, I mean. So I apologize for not being
That's
familiar with
because all the briefs were filed before Berry came down. It was issued in June 24th of this year.
Is it a compliment to Judge Choflat or to Judge Wilkinson that you?
Right, yeah.
I don't want to get in the middle of that.
Can I understand what it is that you think should have happened? And I think I follow 95% of it. You think the district court should have dismissed the charges, should have stayed the dismissal for 2 to 3 days, which would have allowed the warden to decide whether to issue a 4246
Yes.
certificate. What authority and Mr. Williamson would have remained detained at Butner for those 2 to 3 days.
Yes.
What authority would the district court have had to extend Williamson's detention by those 2 to 3 days? Would it be the pretrial detention authority?
No, well, if you vacate the order, as Judge Rouse said, and the dismissal was no longer in effect, then he's back in pretrial proceedings with a 48.
Just to clarify, I'm not talking about
sorry.
what we would do. I'm talking about what you think the district court should have done originally.
Oh, originally, yes.
Dismiss the charges, stay the dismissal, extend the detention for 2 to 3 days.
Yes.
And under what authority would the district court have extended the detention by 2 to 3 days?
Well, I think if they stayed the dismissal, I think I was trying to be reasonable in the district court, and not have some opportunity for the director to file the certificate if they wanted to, but, and that may have been wrong.
No, I think
may-
that's right.
no.
Would the
Can't just, like-
authority be 3142?
Pardon me?
Would the authority for
Pre-trial
that,
detention.
yeah, would be just pre-trial?
If
detention.
there's, so it, yes, I mean, if he had dismissed the charges, I think I shouldn't say this, but I think a district court may have some limited inherent authority to stay a decision for a minimal period of time in circumstances like this. But I don't think they have the inherent authority to do much else, anything else that was done in this case. And the Supreme Court has been quite critical of the exercise of inherent authority, the exercise of something under the rubric of inherent authority.
The detention would have been extended 2 to 3 days.
Yes.
As authorized by the court's inherent authority.
Well, I guess a better way might have been to have the district court say, I'll consider this, I'm going to grant this motion, but I'm going to wait 2 or 3 days. That might be better in the sense of that the detention would be authorized, but I'm just telling the government on 3 days from now, this motion is going to be signed.
I don't understand what the problem is. I mean, your client was being held pursuant to a pre-trial detention, right? And until the indictment is dismissed, he's held there. And he's the one that was responsible for many of the postponements. He didn't want to come to Washington because of he'd lose his files, so keep me at Butner, pending the trial. But as long as that indictment is outstanding, then it's no inherent authority. He already, it's just 4241 or whatever it is.
I don't disagree with you, Judge Randolph, that the delays, we never argued the delays were
I know,
not,
yeah, you
were
didn't
the
argue.
government's fault or anybody's fault. But I think what I was trying to get at is if Judge Walton dismissed the indictment, there would be absolutely no authority.
Oh, if he
Hold him on.
dismissed it, yeah.
Yes,
Yeah.
if it was dismissed, there would be no authority. And I was saying that he might have the inherent authority to stay it for 2 or 3 days.
Okay.
And certainly that was not contested in the district court. Let me put it that way, that he would be able to do that for a very minimal period of time. Thank you.
Mr. Kramer.
I can even see without the glasses with the lights.
Revelation.
Good morning, Your Honors. Alea Lloyd on behalf of the United States. May it please the court. The district court permissibly extended the defendant's detention temporarily in order to facilitate the purposes of 4246A and gave the Bureau of Prisons Director notice and opportunity to effectuate the purpose of the statute, which was to make the initial determination on whether or not this defendant should be detained prior to being released.
So Ms. Lloyd, I think it's interesting that you began by saying this fulfills the purposes of the statute. But here Congress has legislated a very specific statutory scheme for civil commitment, given the important liberty interests at stake. So where is the statutory authority for what the district court did here?
So I think it's important, Your Honor, to recognize that the defendant was already on pretrial detention when this occurred. And so the court certainly had the authority under, I want to say 3142, with the defendant already being detained, to issue an order like this and then continue that detention, especially given that the court stayed the motion to dismiss. So that's where the detention authority comes from.
Well, even if the detention comes from 3142 pretrial detention, where is the authority to order an evaluation or an examination?
Yes, so the authority to order the evaluation or examination isn't, I want to construe the order appropriately. The word to examine in order to make the determination we think was a little bit inartful, but the gist of it is that the district court was giving the Bureau of Prisons Facility Director the opportunity to make this determination, which the statute contemplates. As you look at the Senate report creating the statute, it is the director's responsibility to determine preliminarily whether the defendant should be released. So what the district court was doing here was giving the facility director that opportunity to make that preliminary determination. Whether the term is evaluate, assess, examine, it all means the same thing under the statute. The facility director has to certify that the qualifications for a certificate are met, and that necessarily entails some sort of evaluation. And so here, the district court's order merely just gave the facility director notice to say, hey, the triggering event has occurred. I'm dismissing this case. I know you need time to figure out whether or not you're going to file this statute, which entails the facility director saying, not only that this defendant is suffering from some sort of mental defect that would create a danger to others or their property, but also that there's no available state custody arrangements that can be made. So let me give a little bit of time here for you to make that determination. It was just sort of throwing up a flag saying the triggering event that you need to make a determination has occurred. I'm giving some time. Do with it what you will. Either file the certificate or don't file the certificate. But the district court has to be able to give the director some time in order to accomplish this initial determination.
But now a great deal of time has passed.
That is correct, Your Honor, but that's only because the defendant asked for the district court's order to be stayed pending this appeal.
But I don't understand that answer, because I think according to you, the warden did not need an order from the district court in order to make whatever assessment is necessary to decide whether to issue a 4246 certificate.
Well, the warden certainly needed a major part of that order, which is the dismissal of charges. And so the statute, unfortunately, is a little bit of a catch-22.
I agree with you about that part. I think that is weird in its own right. But the warden doesn't need the mandate to issue on a dismissal of charges, because you were going to have the 45 days with the mandate stayed. So I'm not sure what the warden has needed for the past year and a half that the warden wouldn't have had, even if there had been no appeal.
Well, the government doesn't control the warden, but I imagine the warden saw the stay of the order as a decision to allocate resources appropriately and wait and see how this was all going to shake out before it took any steps. As Judge Randolph has sort of already intimated, this is a very backed up process. There are a lot of defendants, there are a lot of resource constraints for the BOP.
I mean, that is I know it's not your fault that that answer may be the best answer, but I asked basically, why has it not already happened for a year and a half? And your answer is, well, maybe the warden had other priorities. For a year and a half?
Your Honor, I'm not sure why the warden is waiting, but the decision to file the certificate is completely within the warden's hands. There's nothing that we can do on our side to say you have to file it. The warden has absolute control over that decision. We can only do what we've done in this case, and what other district courts have done in all of these cases, which is give the warden the opportunity to file
Why
it.
do you even want the 45-day extension of the detention?
Well, we believe that was a reasonable amount of time, given the resource constraints we know
You
that
just said a
exist.
year and a half is not a reasonable amount of time, so I don't know why 45 days would have been a reasonable.
Well, again, Your Honor, just to clarify, we wanted to give the warden, and we believe that it's necessary, as other courts have also held, to give the warden time to make this decision at the moment when it all occurred. What the warden is doing currently, or why the certificate has not yet issued, is not something that we can order the warden to do or the BOP to do. We can merely, when we finally give the triggering event the ability to occur, which is the dismissal of all charges for reasons of mental issues.
I understand that answer. And this is changing topics a little bit. Just want to confirm, if we, the panel, think best, I'm not saying we will, but if we think it best to read the district court's order to dismiss the charges, stay the dismissal, and extend the detention for 45 days
Yes, Your Honor.
without, as a formal matter, ordering an exam,
Yes,
you
Your Honor.
think that we can read the order that way?
I think that's definitely how the order can be read, Your Honor. And that's simply because the district court is
We-
doing nothing more than saying, here's the triggering event, it's occurred, do what the statute contemplates, which is make some sort of determination.
If we read it that way, would we affirm, or would we dismiss the appeal for lack of jurisdiction? Because it's not, you can't bring an interlocutory appeal for the extension of pretrial detention.
That's a very good question. I think you could affirm, but if you wanted to do, the government's position has been that there is jurisdiction here. And I would submit that jurisdiction still exists, even if you read the order that way, given the fact that given the fact that we're in a sort of 42, 46 twilight zone. And rather than say that there's no jurisdiction in these types of matters, the government believes that this is something that can be reviewed.
He's still under the pre-trial detention order.
That's correct, Your Honor.
And the order that went to Butner, the Judge Walton's order, said that he's going to dismiss that indictment, right? Pending the examination. He's not going to dismiss the indictment until the director of the facility decides either to grant or not to grant a certificate, 4246 certificate, right?
I think you should read the order as saying that the defendant shall remain at FCI Butner for a reasonable period of time, not to exceed 45 days, to facilitate the director being able to file the certificate. And the dismissal is stayed pending the completion of that evaluation and determination. So it's tied to the 45 days or whatever reasonable period of time needs to occur, not to exceed 45 days. So in that sense, we believe, the government would believe that once 45 days is ended, unless the director files some sort of notice with the court saying that he or she needs more time, at that point, the case would be dismissed.
Right, yeah, but we never got to that point because he stayed this order pending appeal.
That's correct, Your Honor.
So once this order clicks in, then it's 45 days he's going to be held for the examination.
Or some reasonable
Or it
period
could
of time.
be-
It could be much less than that. And
Same thing happened in Berry, and the director of FMC at Butner said, I need another 30 days, and the district court granted it.
I believe that's correct, Your Honor, and that's what's happened in a lot of the district court cases and
Right.
some of the other circuit cases we just
Do you know whether
cited.
there's more than 2 facilities that are capable of doing 4246?
I'm only aware of 2, but I know that in the past there has been more, given the case law that exists. But at this current time, I'm only aware of at least 2.
What's the other one besides Butner?
I am not sure.
Okay. Do you think that it's accurate in the order to say that it's whether the director of FCI Butner should file a certificate? Shouldn't it be the director of FMC?
Your Honor, I think the statute contemplates it's the director of the Bureau of Prisons facility, and I think that would.
That would be FCC, not FCI. It's the Federal Correctional Center.
Yes, Your Honor, I think it would be the ultimate director of the entire facility, which would encompass both the corrections and the
It's not
medical.
what
center.
happened in Berry, it was the FMC. Anyway,
I would hope that the director would understand, the facility director would understand who they need to have to issue the certificate. But ultimately, it is the director of the facility that issues the certificate. The court can't order
Right.
the certificate to issue, and that is not what happened here.
He didn't order anything.
The only thing that happened here was a continuation of a defendant who was already in custody and the notice given out to the facility that one of the triggering events that are contemplated by 4246A has actualized. Once that happens, it's only then that the director has the ability to file a certificate which necessarily requires a determination that the defendant meets the requirements of the statute, which are the fact that the defendant could, that the director has to certify that the defendant is presently suffering from a mental disease or defect and that there are no suitable arrangements for state custody. And so that's exactly what happened here. The district court looked at the statute, realized that it had a defendant, which it had already determined was a danger to the community, given that it's holding him pretrial for that specific reason. Noted that if the statute requires the director to only issue the certificate when the defendant is in custody, but the triggering event is a dismissal of the charges, some amount of time had to happen to stay the defendant's release in order to make sure that a dangerous defendant was not immediately released before the director had the opportunity to make the determination that the statute contemplates.
And where do you think the authority for that extension of time comes from? Is it 4246 or is it 4231 pretrial detention?
In this case, we believe that the pretrial detention is the easiest authority to find that under. But we also would note that in other circuits, including the Ninth Circuit, who handled this in Godinez-Ortiz, has found that the district court has the inherent authority to temporarily commit a defendant for purposes of an evaluation. And I think that would also in some ways fall under the pretrial release detention or release authority, because a defendant under pretrial release, the district court also has the ability to order evaluations or mental health evaluations as necessary. And so ultimately, whether you look at the district court's inherent authority or what the district court may do with the defendant that's being detained under pretrial detention, the district court certainly had the ability to order the continued detention of this
But
defendant.
those are two very different legal arguments.
Yes, Your Honor. And the government's position is that you could do it under both, and the government's position is that you could do it under both. But here, the continued detention certainly was authorized under the pretrial detention order.
This is a friendly question. 4246A says, speaking of the director of the facility, he shall transmit the certificate to the clerk of the court for the district in which the person is confined. That suggests an assumption that the person is confined. There must be some authority being assumed that would allow confinement. Maybe it's inherent authority, but I think 4246, do you agree? 4246 presumes that the district court will have some authority to confine the person before the director of the facility transmits the certificate.
Yes, and I think that happens in a variety of circumstances. So, like one of the triggering events is that the defendant is getting ready to be released from from a custodial sentence. And so at that time, the defendant's already in custody of the Bureau of Prisons, so that takes care of that issue. Another one is where the defendant's already committed to the custody of the Attorney General, and so that would take care of it under that issue. In our particular case, it's when the criminal charges have been dismissed. And in our particular case, as I think the defendant cites in the Carrington case, the criminal proceedings are still ongoing. And so the district court here, as the court with the jurisdiction over the criminal proceedings, certainly had the authority to continue the detention it already had instituted.
Okay, thank you, Mr. Mr. Kramer, we'll give you a couple minutes. And
Thank you. I just want to say preliminarily, the pretrial detention argument that government was making now was never argued in the district court or in their briefs on appeal. They've argued solely on 4246. And I want to say they have now disavowed what they asked for in their motion. It was entitled motion for an evaluation pursuant to 18 USC 4246, and they said for a reasonable period not exceeding 45 days to be examined to determine whether they should file it. And then on page 13 of their motion, I'm sorry, page 14 of their motion, they said he should be evaluated to determine whether his release would put the community in danger. And they said this court should order an evaluation to allow BOP to determine whether to file. And they ended up by saying that the director should be given an opportunity to evaluate the defendant for dangerousness. This is not just a certificate. And they ended by saying for 45 days so that he can be evaluated for dangerousness and for a decision by the director. Now that 45 days is for a full 4246 exam. That's what the statute permits for a full exam. This issuance of the certificate, and I think I have to revise something I said. So when we were in the district court, I said that the district court could stay its order for a minimal period of time because it should dismiss the charges. And now we're way past that. We're over a year or a year and a half past when this order was first entered by the district court. I guess it was filed, we're well over, it was filed in December of 24. So there has been, I think it should just go back to the district court for dismissal at this point. Butner will be given, if this court were to reverse, Butner would have 45 plus 7 days before this court's mandate would issue to the district court. And then it would, Judge Walton would have to either issue a written order or set a hearing in court.
Here's the way Judge Wilkinson responded to arguments like that. I'm just going to read this to you. It would make little sense to interpret the statute to require the release of dangerous, mentally incompetent individuals the moment their charges are dismissed without affording the government a reasonable opportunity to seek a certification under 4246.
I'm not sure I disagree with that as a principle, but that's not what the statute says, first of all. And the Supreme Court has said you don't read words into the statute that aren't there. And second of all,
I think we're dealing with an issue that is not, I mean, I tend to agree with you to the extent that the order here is not an order that you can look at 4246 and say, 4246 just doesn't cover the question, how do you give the government an opportunity before you dismiss the indictment?
well, then you're doing exactly what the Supreme Court says is impermissible. The court will presume that the legislator says what it means and means what it says. We have repeatedly stated that the text of a law controls over purported legislative intentions unmoored from any statutory text. The court may not replace the actual text with speculation as to Congress's intent. I think that covers this precisely. Also, Judge Walton's order clearly requires an evaluation. And two things. Mr. Williamson has already had an evaluation he should not have had because Judge Walton had no authority to issue the.
Yeah, but the evaluations that he had were not 4246 evaluations. They were number one, they were competency and whether he suffers from a mental disease sufficient to warrant him not being allowed to represent himself.
No,
but the 4246 inquiry is whether he's dangerous. You can be mentally incompetent and not dangerous, right? So that it's designed to determine dangerousness.
but Judge Walton had already found him competent to represent himself before he ordered the exam on sanity at the time of the offense. He said he wanted to know whether there was an insanity defense, and that's only permissible under the statute when the defendant is filed notice.
None of those inquiries, I guess were.
No, but what I'm saying is
it deals with dangerous.
he's already been subject to one exam he never should have had. Now the government's saying he should have another exam because it's necessarily encompassed. One thing you didn't hear the government say was anything under the statute that authorizes this exam. And so by the time at this point in time now, it's a year and a half after, or more than that, after Judge Walton issued his order, Butner knows what's going on because Judge Walton even referred to an email he had gotten from Butner about the status of the case and whether Mr. Williamson would be going back to DC. And then if this court were to reverse, Butner would have another 52 days at which they know that the case is going back to Judge Walton. I think it should go back, at this point in time, should just go back to Judge Walton to effectuate his order to dismiss the indictment. To grant, he's already granted the motion, but it should just go back for that. And Butner should not have, at that time, either they will file the certificate immediately or not. They can file it even before Judge Walton does that because it will go into effect at the dismissal. So I don't think they should have any extra time. They're already, if this court were to reverse, they're already going to get 52 more days to have this issue under submission. But there's no way Judge Walton's order can be interpreted that he's just going to stay there for 45 days for them to determine whether to file a certificate, because he ordered the motion for the evaluation pursuant to 4246. I'm not even sure they'll know what that means because 4246 is solely for dangerousness. It's not whether to issue a certificate. And second of all, if they have this evaluation, what happens later if they do issue a certificate? Then there's another evaluation and an evaluation by an examiner, Mr. Williamson has, which is denied to him under this order. And so it's because there's no statutory basis for it.
I understand that you think we should not read the order to stop short of ordering an examination. But if there were two plausible readings of a district court order, and one of those readings would require something that is not authorized by statutes, and one of them orders something that is authorized by statutes, would you agree with me that we should read the order? There are two plausible ways to read it. We should read it the way that would be authorized by statute.
I don't think there's any plausible reading of this that's authorized.
I know. I know you're fighting that. I know we disagree. We may disagree about that.
If you're saying the Judge Walton would just say he's to stay there for 45 days with no evaluation, there's no authority for that either. To have.
Maybe let me just ask it in the abstract. A district court issues an order. It could be interpreted two plausible ways. Interpretation A, not authorized by statute. Interpretation B, authorized by statute. Shouldn't we interpret it interpretation B?
Taking your
very abstract hypothetical.
Taking your prefacing it with the word plausible, when it orders an evaluation pursuant to the request, it has to be plausible. But second of all, because this was never argued in the district court or in the government's brief, I don't think you can just have Mr. Williamson sit there at Butner for 45 days. I don't think there's any authority for that either. So I guess the answer is there's no authority for either one.
Can I just ask about one more thing? You pushed back against Judge Randolph's theory because you thought it was kind of insufficiently textualist. If we were to be sort of hypertextualist and just look at 4246B in isolation, it says prior to the date of the hearing, the court may order a psych examination. And doesn't say anything about a certificate being filed first. And subsection A, which is all about the certificate, doesn't say anything about an examination. So again, if we were going to be kind of as hypertextualist as maybe you were suggesting to Judge Randolph, we would just look at subsection B. It says the court may order a psych examination. Doesn't say anything there about how a certificate has to come first. So as long as the psych examination is prior to the date of the hearing, which of course it was here, then what the district judge will be authorized is authorized by subsection B.
Well, I think that would be a tortured reading of the statute beyond any reasonable, because section 1 talks about the institution of the proceeding, and the other parts are all what happens in that proceeding. And it's only instituted by the filing of the certificate, and then comes the psychiatric exam. And Subsection E is about the discharge. I'm sorry,
Subsection B?
oh, B, I'm sorry, I thought, right. Prior to the date of the hearing, but there's no hearing unless subsection A takes place first.
Well, you could just read subsection B to say that the court may order a psych examination. When can it order it? Anytime, as long as there hasn't been a hearing first.
Well, it says prior to the date of the hearing.
I will say, I'm not persuaded by this, but I think you're sort of asking for, and this is maybe the best interpretation that you're asking for, but you're asking for sort of a Goldilocks version of not as holistic as Judge Wilkinson and not as hypertextualist as what I was saying.
I
Maybe right.
I just think when subsection A says, this is how the proceeding starts, the certificate is issued, the director has to find this, and then it says it's sent to the clerk's office and the court orders a hearing. And then the next section in time says prior to the date of the hearing, not of any hearing or a hearing, but prior to the date of the hearing, that has to refer back to the hearing in subsection A. I don't see any other way to read that, but
I think you're right.
thank you.
Okay, thank you, Mr. Kramer. Case is submitted.
Case number 22-1163 et al. Hospital Menonita de Guayama, Inc. Petitioner versus National Labor Relations Board. Mr. Moldoni for the petitioner, Ms. Beard for the respondent.
Yes, please.
Good morning, Your Honors. Patrick Muldowney on behalf of the petitioner, Hospital Menonita de Guayama. At my table with me, at the council table, is my law partner, Megan Martin. And can you hear me okay? Just want to make sure. Okay, great. As the panel is aware, we're here on a remand from the Supreme Court for reconsideration of this court's prior decision denying review of the board's order order finding an unfair labor practice in connection with the withdrawal of recognition withdrawal of recognition of the majority status of 5 separate units represented by the same union. And we're here to consider it in light of Loper Bright. We would posit that this is the exact case that the Supreme Court had in mind when it issued Loper Bright. That we have here in a situation where the petitioner took over the operations of a hospital where there were 5 separate units, 5 separate bargaining units, all represented by the same union, none of which had executed a collective bargaining agreement for years prior to the acquisition. In fact, 2 of those units had never entered into a collective bargaining agreement. While initially recognized the union as the representative of each unit in accordance with applicable law, Supreme Court precedent, a majority of each unit expressed that they no longer wanted the union to represent them, which prompted the petitioner to withdraw recognition and which prompted the union to file an unfair labor practice charge. At the ALJ hearing, the board implemented the ALJ implemented the successor bar doctrine with an irrebuttable presumption of majority status.
Downey, so we're familiar with the
Sure.
procedural background. So are you here challenging the lawfulness only of an irrebuttable presumption or also a rebuttable? Does the NLRB have any statutory authority here to have even a rebuttable presumption as a successor bar?
We would, at least in an initial blush, go along with Judge Katz's in his concurrence that there's a question as to whether, in fact, the board had the authority to issue this kind of presumption, rebuttable or irrebuttable. However, at the very least, we believe there should, at the very least, if if the court would believe that the board had the authority to issue some type of presumption, it should be a rebuttable one. That's the only one that makes sense. It's the it would be, I think, the best reading of the statute per the Loper-Bright decision and what Chief Justice Roberts said in his opinion. The best reading would be.
What are the terms of the statute that you're interpreting?
Excuse me? Sorry, Your Honor.
What terms of the National Labor Relations Act are you interpreting?
It's the Section 7 rights of employees to engage in concerted activity, to seek representation, or to refrain from doing so. I mean, that's the key.
Is it 8A1 and 8A5 too?
Well, that would be the violations that are being alleged here are 8A1 and 8A5. And so we are arguing that was improperly found, that there was the unfair labor practice for 8A1 and 8A5 were improper because the ALJ applied what we believe is a presumption that's contrary to the act itself.
Where in the language of that of Section 7 can you find the distinction that you make between rebuttable and irrebuttable?
Well, Your Honor, again, our position is that we don't think there should be a presumption at all. But again, the irrebuttable versus rebuttable, the board historically has waffled between the two of them. The Sixth Circuit at one point did, I think it's the landmark case, did find that the rebuttable presumption was under the current review standard at the time, which was again is pre-Loper-Bright, was permissible. They upheld the rebuttable presumption.
The sequence of events was that your client first recognized the union, and then the decertification petition came in.
What happened, Your Honor, was they first recognized the union as the successor because they had hired a majority of the employees in each unit. And then over the period of the next several months, they received petitions and letters from majorities in each of the units. And I think, in fact, in some of the units, it was even every particular member of the unit saying they didn't want the union, they did not want to be represented by the union, so they withdrew recognition.
What about the Supreme Court cases that have upheld other so-called bars to an election, right? Like the so-called contract bar that's been upheld. I mean, how do we make sense of those precedents in light of your statutory argument?
Right. Well, I think
Are those cases wrong too under Loper-Bright?
I would take the position, obviously, that there's an argument under Loper-Bright that they are. But even if we were to say they were not, the other types of bars that have been put out there are really sort of tied to the election bar that's actually in the statute.
Contract bar isn't so much tied to the election bar.
I think that let's put it this way, there's more connection between the contract bar and the election and the election bar than there is between the successor bar, because again, it has to do with the initial formation of a contract and the relationship of an agreement during the term of that agreement between the representative who bargained for it for the employees and the employer.
And here the last election, I mean, they hadn't had a contract even with the unions for a number of years.
Right. And in fact, to the extent that the board has argued that they're trying to protect the bargaining relationship, there wasn't one to protect. There hadn't been any contract that was formed for several years. And stepping into the shoes of the successor, the petitioner receives indication from the various units, all 5 of them, that they don't want the union there anymore because of we can only presume ineffective representation. They did not get it.
What is your position with respect to at the end of Loper? And I don't recall whether you addressed this in your brief or not, but at the end of Loper, Chief Justice Roberts said this. We do not call into question prior cases that relied on the Chevron framework. The holdings of those cases that specific agency actions are lawful, including the Clean Air Act and Chevron itself, are still subject to statutory stare decisis, despite our change in interpretive methodology. What argument do you have that overcomes statutory stare decisis?
Well, there is really.
Besides Chevron,
Right.
because the holding in Loper is that following Chevron in the past is not enough to overcome statutory stare decisis. So what is your argument?
Your Honor, there really, and in connection with this particular issue, there isn't really any, the only extent that there's stare decisis amongst the courts is this, would be the Sixth Circuit that approved a rebuttable presumption. There is no case that prior to the Lilly transportation case and the prior panel here in this court that found, in fact, that the irrebuttable presumption was appropriate.
The
So,
panel here was vacated by the Supreme Court.
correct. And again, our case is currently active. So I would say there's really no stare decisis applicable here in the sense of this case is still going on. So I think the court's free to issue a decision recognizing Loper and applying Loper in an appropriate way.
We could rule for you and still preserve the language in previous precedents that says the statute gives the board discretion to make labor policy.
That's correct, Your Honor. I mean, there's the, I mean, when you look at the cases that were decided previously, a number of those Supreme Court cases dealt with issues of factual determination, which Loper doesn't change. Loper says that if there's a factual determination by the board, as long as it's supported by evidence.
Okay.
And, you know, so,
I agree. And then this is something of a technical question. I think in one of the briefs says the hospital purchased the assets of its predecessor and voluntarily recognized the union that represented 5 separate bargaining units. That voluntary recognition of the union, did that happen kind of automatically once the old employees were rehired, or after they were rehired, was there then a sort of voluntary affirmative act by the successor, the new company, to say, we recognize the union?
I think the record shows some correspondence back and forth between the union and the petitioner. And it was as they were hiring on employees. I mean, so obviously
You're saying it's more the second. It was an explicit affirmative statement by the company. We voluntarily recognize the union.
Well, that we'll sit down and meet with you and bargain over the terms and conditions.
Further questions?
Thank you, Your Honor.
Good morning, Heather Beard for the National Labor Relations Board. I'd like to start with a statement that my friend on the other side made, which I agree with in part. He said that this is the exact case that the Supreme Court had in mind. I agree with him up till that point. He then said, in Loper Bright, and I would add to that sentence, that this is the exact case the Supreme Court had in mind, not to be disrupted by Loper Bright or affected by an overturning of Chevron, but the Supreme Court for 90 years talking about the board and its authority from Congress to set labor policy.
Ms. Beard, I think you can argue that maybe the Supreme Court didn't have this case in mind either way, but hard to say they had affirming this case in mind when they decided Loper Bright, since they immediately after Loper Bright vacated the panel decision in this case.
Sure, I'm not sure we could read anything textually into their vacating the earlier decision and doing a GVR in terms of the fact that Loper Bright came out and there had been an allegation by my opponent that the original panel had talked about or had relied on Chevron. Our position has been the earlier decision, which I know was vacated, did not rely on Chevron. And the National Labor Relations Board does not rely on Chevron. Loper Bright overturned Chevron, and Chevron was one new form of deference that the court said in Loper Bright had never before prior to that been used or adhered to. And in those cases where the Supreme Court, in fact, Allentown Mac is a Supreme Court case that was cited in Loper Bright. And Allentown Mac was a case which upheld the presumption.
So, Ms. Beard, I mean, the Supreme Court and our court has recognized that the NLRB has, a certain amount of interstitial rulemaking or policymaking authority. The question is, do they have the statutory authority to do the presumption in this case? And so to that point, I'd like you to, where is the authority in the National Labor Relations Act for this type of, the board refers to it as a time bar, but it's not really a time bar. It's really suspending the operation of the NLRA for a period of time. And where does the board have the authority to do that? Under the statute?
Sure. Let me back up for 1 second. You had asked the question of stopping the NLRA. I would disagree with that respectfully, that it's actually effectuating the NLRA to have a bar for labor stability. So that's number one. And where that is, right, that question we would submit is not what is before this court, because the Supreme Court has already resolved that the board, that Congress has decided that the NLRA has the authority to make labor policy, in not only labor policy for labor stability to balance Section 151 of the Act, which talks about collective bargaining for labor stability, but with Section 7 of the Act.
You're not answering my question. So, let's look at the statute, okay? Not just the general policy making, right? So Section 7, employees have a right to collective bargaining through representatives of their choosing. Section 9A says representatives have to be chosen by a majority of the employees. And what the successor bar does here is prevent employees from exercising Section 7 and Section 9A for a period of time after there's a successor employer, right? It basically suspends the ability to choose a representative by a majority for a period of time. So where in the Act is there an authority to suspend those provisions of the National Labor Relations Act?
Sure. Well, they're in the Act. The board under Section 160A is empowered to prevent any person from engaging in any unfair labor practice affecting commerce. And the Supreme Court.
How is it an unfair labor practice for an employer to say, I'm going to recognize, or call for an election or whatever to make sure that there's a representative by a majority? I
think that the Supreme Court has already answered that question in the Osceola case, which upheld the contract bar, which is a similar, if you want to call it a bar or an irrebuttable presumption, saying that there can be a suspension sometimes in the balance, that the board is the agency that Congress specifically and consciously entrusted with balancing stability in labor relations, giving the employees under Section 7
So that's a pre-Loper case, and it's not this particular board doctrine. It's a different doctrine.
It's a Supreme Court decision on a doctrine based on the same labor stability principle. And it's a Supreme Court decision which was not disturbed, wasn't talked about explicitly in Loper. And it's a Supreme Court decision that comports very much with Allentown Mac, which—
But you still haven't given me any statutory reason. So Loper says the first question, and frankly, honestly, I think this was even the question under Chevron. I don't think Loper actually so much necessarily changes the outcome in this case. But the first question always is, did the agency have the authority to do what it did? And you have not yet pointed me to any source of authority for this successor time bar.
Sure, I'm going to, if I may, Your Honor, if I can respectfully point you to some really good authority in Loper itself, which is at
statutes. Let's go to the statute.
Right. Well, Loper talks about the statute. It says that—
No, it doesn't talk about the NLRA. Let's talk about this statute and what the board did here. Where is the authority under the NLRA?
Sure. Well, again, I don't know that the authority under the NLRA in a statutory piece is necessary here where the Supreme Court has already said it exists, where the Supreme Court has said.
I would like you to show me what is the NLRA authority. If you don't have any, then I'll just.
No, I think what the Supreme Court was doing in those cases was looking to the National Labor Relations Act as a whole, as a statute that was passed back in 1935 with the statutory provisions that empower it to determine whether or not there is an unfair labor practice. Why does the board get that power? As they say in Loper at 394-95, if Congress has given such discretion to an agency, the National Labor Relations Board sets labor policy because Congress
So you don't
decided
have
it
any-
should.
You don't have any statute.
I disagree with you. The statutory authority is in section 160A, section 160C, where it says that the board shall be of the opinion that any person named in the complaint has engaged in a ULP. Then the board states its findings. You take 160A together with 160C, the preamble, section 151 about stability and
So you're
collaboration.
claiming that the board can override for general reasons of labor stability, any specific provision of the National Labor Relations Act? 'Cause you have
Absolutely not.
You have not explained to me why this general authority allows the board to suspend section 7 and section 9A. So if
Sure,
you don't
I
have a
disagree.
statutory provision, that's fine.
No, I
Like, I'll
think,
stop asking you, but you keep saying you do have one and you don't give.
but
me
I
one.
think I'm sorry, Your Honor. Respectfully, I think that I have given you the statutory provisions in the Act, section 156, section
So just the
160.
general authority. So board can kind
That's
of
a
do
s-
whatever it thinks
No.
ensures labor stability.
The board has to, and that's the part of this case maybe that Judge Walker was talking about. Once there is a congressional authorization from the statute, and we think, again, this has been settled by the Supreme Court that there is for Congress to delegate labor policy, that does not mean the NLRB wins. There are two parts of Loper which say, in that situation, what this court should do is take a look to ensure that what the NLRB did was police the boundaries of what its delegation is and do it within the statute and do it with reasoned decision-making, which is consistent with
So
the
agency
APA,
gets
yes.
to police its statutory.
Well, no, the agency, this court can decide whether, I'm sorry, I misspoke. This court gets to police whether the agency has acted within those acted within those boundaries. And and the court has the ability to police whether the agency has exceeded them. And I think from back in the UGL case, back in 2011, when the board explicitly and thoroughly explained why it is that the successor bar, like the other bars before it, provides a labor stability and that it gives a balance, that is reasoned decision-making.
That's fine. I'm not getting the. Colleagues have any.
It sounds like you're saying there are lots of provisions in the act that together provide you the authority to do what you did. Is that fair?
I think I'd add one thing to that, Your Honor, and I would add to that, plus the Supreme Court saying that Congress delegated this. Okay, but other than that, setting that aside, what I'm arguing is that, yes, the structure of the act with all of its provisions and how it acts, absolutely, and there's no barrier in this.
And then among those many provisions that provide you the authorization, which is the best provision for you?
Okay, I would say it's hard to pick because together, when you pull a thread from the statute, it's difficult. And all of them give the board the authority to be the agency that creates national labor policy with judicial review for rational and consistency. So I would say that my best authority is the Supreme Court for 90 years.
Authority.
And the statutory authority would be sections 160A, 160.
What is the best statutory provision for you? I'm not saying you have to rely entirely on it. I'm just saying.
For me personally, what's the best one?
What statutory provision best supports your argument that the NLRB had the authority to do what it did?
160.
Okay, and what does it say?
160A, the board is empowered to prevent any person from engaging in any unfair labor practice affecting commerce. And 160C says the board, if upon the preponderance of testimony taken, the board shall be of the opinion any person has engaged in or is engaging in any such unfair labor practice, then the board shall state its findings of fact and issue an order requiring such person to cease and desist from such unfair labor
Does that-
practice. And that gets reviewed by.
Does that give the board the authority to define anything as an unfair labor practice?
Well, if we want to talk about defining the unfair labor practices, those are defined in the statute in section 8.
So is there
Section-
an unfair labor practice for a successor employer to have to?
Yes, there's an unfair labor practice that says a refusal to bargain with a representative of an employees. It's section 8A5 and section 8.
Right, a representative, but the board then defines the board is like saying that an employer, successor employer has to wait to figure out, can't recognize a majority representative.
Well,
for
first,
their
it's not
employees.
the board only that's saying that. I mean, the Supreme Court said in Fall River Dying that a rebuttable presumption, the Supreme Court said, and authorized the board to have the authority to do that. And that kind of a presumption, a rebuttable one, is one apparently my opponent agrees is something the board is authorized to do. So now we're left with, can the board create an irrebuttable presumption?
How long is this presumption irrebuttable?
The presumption is irrebuttable either if when the two scenarios, if like happened here, if Hospital Menonita, the successor comes in and decides that it is going to recognize the employees like it did, it's a minimum of six months. And it can be extended up to 12 months, but those are the outer boundaries. From 6 months to a year, what the board has decided
Who decides whether it should be extended?
in terms of what is reasonable. This court's decision actually in Lee Lumber talks about,
There- 6 months is about to expire.
right.
Okay, who decides whether that gets extended to 12?
Well, the parties would decide, and if they decided that it was too long, if one of them did it past 6 months and in 12 months would have been more reasonable, that would be something that they would argue about, and possibly the general counsel of the board would issue a charge if it was or wasn't reasonable. But that's exactly identical, like I said, to the bars and the bargaining order bars that this court is blessed.
After an election, what is the bar? What's the bar by by statute? The union gets a majority vote. What's the bar then?
Right. After the union is certified, it's 1 year,
1 year.
12 months, yes.
Does that apply to union authorization cards too?
You mean sort of when the union presents a majority of cards and the employer
Right, and the employer doesn't have a quote good faith doubt
Right.
about the union's majority status? Does the 1 year bar kick in?
There is what we call the voluntary recognition bar, which is my understanding as of right now, there is such a bar, but there have been proposals and rules proposed is to give 45 days to an employer to come in and say, we do think that there is a doubt.
Yeah.
So that's a
but-
different.
So why doesn't that, rather than 6 months to a year, why doesn't that, the voluntary recognition bar, why doesn't that apply?
Well, here at least, this case, what was litigated and what the board found was that this was a failure to bargain based on the fact that there was a successor, and that successor bar is what the board considered. But to the extent the employer had made any such argument that there should have been,
The employer voluntarily recognized the union.
right, but that wasn't based on cards. That was based on its
I
success.
understand that. It was because they hired a majority of previous employers, people, right?
Right, and they agreed
Right.
they did that, right.
Yeah, but I don't understand why that's voluntary recognition. Why doesn't the voluntary recognition apply at 45 days?
Because under the case law and in the Fall River Dye case, which talked about when a rebuttable presumption, the law that is applied under the successor bar that the board has applied is not a voluntary recognition bar. When there's a successor that comes in and there's been a union in place, and that union here had been in place for many years, what the bar that the board has always applied is the successor bar. I don't think that anyone has raised an issue like that in this particular case, nor do I think that
No, I
affects.
haven't raised the issue. I just wonder why.
Sure.
But, never mind.
I'm not sure of the answer to that, other than the precedent with the successor bar.
Just out of curiosity, if the Attorney General called the General Counsel of the NLRB on behalf of the President and said, confess error in this case, what would happen?
Okay. Can you say that one more time?
The Attorney
If the-
General calls the NLRB General Counsel, I think is William Cowan, and says, the President wants you to confess error in this case.
I think you would have to ask Mr. Cowan. He's subject to removal he's the acting general counsel. And I know that there's cases that have held that the general counsel of the National Labor Relations Board is subject to removal by the president at will. So that's what I can tell you.
Thanks.
So we didn't get too much on the statute, but you were relying on the Supreme Court's decision in OCLO. And in that case, that did involve a contract bar. But the opinion, as I read it, was a relatively narrow opinion, which suggests that the employer there was not entitled to an exemption from that rule. So the Supreme Court in that case, I'm not sure I don't think it was challenged, the contract bar, and the Supreme Court certainly didn't affirm the contract bar. They just said that the employer there was not entitled to an exemption. So I'm not sure how that case necessarily, I mean, besides the fact that that bar is different from the successor bar, the reasoning of that case, I'm not sure particularly supports
Sure.
what's happening.
I would argue that it does, and that there is no sort of, if the NLRB was suspending operation of the NLRA by impinging so hard on employees' Section 7 rights that they can't have an election, if that was how the labor stability was balanced, I don't think that Osceola could come out the same way with the same language used. I will point you, though, if you don't like Osceola in that regard, Brooks, which is the Supreme Court decision from 1954 about the certification bar, that there is very similar language in that case from the Supreme Court about why a short temporary bar, it does not impinge on employees' Section 7 rights as much as what it does is balance. It's a reasonable and reasoned decision-making way to talk about the balance between the employees and their representative having a period of stability for the collective bargaining agreement to work, to have labor peace.
Certification bar seems to me to be well supported by the statute, because you have to have a way of reading, 9C1. 9C1 and 9C3 together. And the certification bar seems to be a way of reading those two provisions together.
Well, what the court said in
So it
Brooks,
doesn't need to have like a general policy-making, authority for the board.
sure, but I think any balancing that the board is going to do in stability of collective bargaining relations, and then when, as I think it was in Osceola, when the Supreme Court said, when an employer says, I think my employees don't want the union, it's almost inimical to rely on an employer saying, my employees don't want the union, and therefore we should have therefore we should not have the relationship in the collective bargaining anymore. So I think that for all of the cases where there's been some balancing by the board, with regard to the labor representative and do the employees not want the labor representative, is I think, there may not something be directly on point upholding the successor bar in this case, but certainly, as the Supreme Court said in Allentown Mac, the board can adopt counterfactual presumptions, and as long as they are subject to reasoned decision-making and are reasonable, they should be upheld. And the board, sometimes the courts say, the Supreme Court said in Allentown Mac, we don't think the board did something reasonable here. But all throughout the line of cases the Supreme Court was saying is that the board has the ability to balance those parts of the statute. And that's what happened in this case. And we think under Loper, the board exercised its discretion in a way that was consistent with the statute and rational. And we would ask that you uphold the board's decision.
Thank you.
Thank you.
Mr. Baldani, we'll give you 2 minutes on rebuttal.
Very much.
Mhm.
Judge Rao, your discussion of the Osceola case, I would just add on to what you had said was that case really, if you look at it, is really more of a bad faith bargaining case, because what happened was they agreed, the union, they had given an offer to the union, and then all of a sudden said, oh, we have this doubt as the majority. And the board found against the employer on that. But there's an interesting footnote 6. It says, we note in the unusual circumstance in which evidence leading to the employer to harbor such a doubt in terms of such a doubt at the same time the union accepts an offer, that being a doubt of majority status, the board has agreed to examine such occurrences on a case-by-case basis. So even in Osceola, the board's operating under the assumption that that case-by-case analysis makes sense, which is the same issue here. You have a finding of loss of majority status after the bargaining relationship between the successor and the union commenced. So I'd argue that would belie what the board's arguing here. As to the Loper Bright's applicability to prior case law involving the NLRB, first of all, this case, when you look at the Lilly case, Chevron is all over the Lilly case. Justice Souter, in his opinion, relies heavily on Chevron, and the panel here relied heavily on Lilly Transport. So Chevron is in play. But even so, while you have prior Supreme Court decisions, they need to be reviewed through the prism of Loper Bright, because that's the pronouncement of the Supreme Court on how the judiciary is to address administrative decisions and administrative rulings of law. One other point I would just make, that on the Allentown case, that was again a fact-finding issue. In fact, and even in Loper Bright, the fact-finding
Not only
standards.
that, but the NLRB lost.
They lost.
Yes.
Yeah.
I don't understand why that's, put out as some kind of case that supports.
And I would agree with you. I would agree with you, Your Honor. But again, even if you take that as a supporting precedent, it supports on a fact-finding issue, not on a finding of law, which the successor bar here is clearly a legal finding. I mean, I think the Lilly transportation case, I think Justice Souter actually said that and made it clear. So we would argue, to the court that the court should invalidate any, we would say, at the very least, invalidate the irrebuttable presumption. We would be more than happy to see the court get rid of the presumption entirely, but at the very least, be able to send it back to the board, have an adequate evidentiary hearing where our evidence is considered, and that we have it. And so, respectfully ask that the court grant.
What is the situation that has occurred during all this lengthy litigation? Is the company or the hospital bargaining with the union now?
No, the union is not. No, there's no bargaining going on. The employees are, from all reports, are happy with the terms and conditions. And the union has not really been very present. I think maybe the last time they really had any substantive hearing about anything from the union directly was when this court previously made its ruling. But since then, there's not been. Okay. There's still no bargaining relationship. There wasn't one before we came in, and there isn't one now.
Yeah.
Thank you very much.
Case is-
Friday, December 5th at 9:30 a.m.